87, 88 of CRPC. Now, I already told you section 88 deals with the issuing of, what do you call, summons and warrant. So here, when NBW has to be issued, what are the circumstances that should be considered by the court while issuing NBW? First fundamental principle is, it is only in exceptional case NBW has to be issued. So, issuing NBW is an exceptional circumstances. As it is not a rule. Okay. Because the concept of bail is not punitive nor punishment. Punitive nor preventive. Punitive or punishment is one and the same. Preventive. Punitive or not preventive. So that deprivation of liberty is considered punishment. Normally, what is the concept is, the accused should be punished after granting of conviction. But what is happening when punishment should be begin? Punishment should begin when? Should begin after conviction. But because of this bail procedure, even before conviction, when trial is going, he is being lodged in jail without granting bail. Suppose after completion of the entire trial, it is ends with acquittal. Then what about this incarceration, jail? So, punishment should only begin after conviction. That should be keep in the mind. Okay, then, so that in granting bail, liberal view must be taken. Okay, then, now come to circumstances clearly laid down by Supreme Court in Mohan Gopal case. We will come later. Before that, section 309. Section 309, already told you yesterday, it is dealing with the adjournment. It is dealing with adjournment. I am not going to give details about the complete details of section 309. With related to bail only, we have to discuss now. We go in detail about that section when that chapter we reach. So what is section 309? 309 also empowering the magistrate to remand custody further. To remand custody, to remand him further. So, not exceeding 15 days. Not exceeding 15 days at a time. Not exceeding 15 days at a time. So, bail, the concept of bail comes here also. It is speedy trial concept. The section mainly deals with speedy trial. What is that? Why this section is being touching upon by the court is that if there is no delay on part of the accused, only delay is caused by court or prosecution, then it is violation of Article 21. For that reason of the court and prosecution, the accused should not be trial, should not be punished. So that delay should be deprecated. So section 309(2) prohibits adjournment, and it is saying that speedy trial is facet of Article 21. You should complete. Okay. So that is the relevant portion of section 309 to us at present. Okay, next. Bail should be granted even by taking personal bond. Even by taking personal bond. The court long ago in 1980 has given certain guidelines in Hussainara cartoon case. What are the parameters to be taken into the consideration while granting bail basing on personal bond? So, if the court is going to give bail on personal bond, the roots of the accused in community has to be taken into consideration. Roots of the accused in community. That means, suppose if the accused is having long-standing residence, he is residing there from several years back, decades back. If there is no deterrence from fleeing. So, when there is no chance of fleeing from the trial, when there is no chance of absconding from the trial, why all sureties and other things and a lot of burden to the accused? Even by personal bond, he can be safely released. But the accused should have roots in the community. The accused should have roots in the community. So how will you decide that the accused is having roots? For that, we have to take these parameters. 8 parameters given by the Supreme Court in Hussainara Cotton case. What are those? The length of the residence in the community, how long he is residing, what is his job, history and financial condition, family tie-ups and relationships, whether he is having any relations within the community, family, and his reputation, character and monetary conditions. What is financial position? What is his reputation in society? Is he having any criminal record? Is he having any criminal record? Previous convictions are there, previous bails are there. We have to take into consideration. And then can any other person can identify identify about him, what you call the accused. So who would vouch for his reliability? Can anybody come and stand as a guarantee? Yes, he is a reliable person. He is good person. No problem. He can be taken into consideration. Is there any such persons to say? So all these things have to be taken into consideration. And the nature of the offense. If it is a petty, of course, even it is below 7 years or up to extend 7 years, non-cognizable and non-bailable. Even in this case also, arrest is not necessary for all the offenses. So what is the offense? 420 is 7 years, punishable with 7 years. If you cheated up to, there is allegation that 10,000 he has cheated, it is also 420 up to 7 years. Then, so we have to take the nature of the offenses charged and apparent probability of conviction also, and the likely sentence. So all these things has to be taken into consideration, and any other factors to relate to the roots of the community will failure to appear. So these are the parameters given by Supreme Court in Hussain cartoon case. So these are the, when court grants bail, these should be taken into consideration. We must also know, while filing a bail application or imposing conditions by the court, we can suggest this thing. This is the guideline given to judges to follow by Supreme Court and High Court to the lower judiciary, Sessions Court and Magistrate Court. So this is one important aspect. Now, the next issue is that another judgment is there which deals with the speedy disposal of the cases, particularly bail. That is Hussain another versus Union of India 2017. This is also latest guideline to the judges. Now today we are clearly dealing with the guidelines given to lower judiciary. So while granting bail applications, what is the mind of the judge? We can understand if we read this subject, read this today, what do you call it, judgment or guidelines. If we know this, we can understand on what parameters bail can be granted or rejected. So bail application disposed within 1 week. That is the judgment in Hussain another versus Union of India case. So there is a time limit for a conclusion of trial. Suppose custody trials. What is the meaning of custody trial? Trial is going, the accused is in custody. In such a case, if it is a magistrate, the trial is going before a magistrate within 6 months, the trial should be completed. Suppose it is in a sessions court, the trial should be completed 2 years. That is the timeline set by the Supreme Court in this case. If suppose a case is pending for since 5 years, it should be dealt with fast. So effort should be made to dispose of all cases which are 5 years old. 5 years old cases are priority. Priority should be given to those cases. And another thing is there, that is, we know that section 436A of CRPC. What is section 436A of CRPC? Section 436A of CRPC deals with the under trial prisoners when they have to be released on bail. That is a mandatory bail. 436A. Suppose accused is languishing in jail and who completed one half, that means 50% of his punishment, maximum punishment. Suppose if he completed one half of the imprisonment can be granted punishable to the offense for which he is languishing jail, he shall be released on bail. That is 436A mandate. We will come to that later. So here in this case, supplementary to 436A, but to the spirit of that case, what is the Supreme Court held that not only there is no need to wait up to that. Suppose the accused undergone sentence in excess likely to be awarded. In excess likely to be awarded. Suppose accused undergone the imprisonment sentence in excess likely to be awarded. Suppose 7 years punishment maximum. Normally, the court grant 5 years or 4 years. Normally, a court will not grant maximum punishment. Suppose the accused suffered the imprisonment up to 5 years or 4 years or 6 years. Then the court can, of course, it crossing one half. Or there is no need to wait one half. The likely, we don't know how the sentence will be granted to him, awarded. But the court feels that in this case, maximum we can grant this much of sentence. If the accused suffered that imprisonment in exceeds to that sentence, then court can grant bail. That is the direction of the Hussain and another case. But how it is, the assessment must be made by the trial court from time to time. How it should be assessed is depending upon case to case. So these are the guidelines given in this case. Next. Section 436 of CRPC. So I already told you one half of the sentence is the limit. There. Here, while computing how the one half 50% sentence will be reckoned. How it will be reckoned? You have to take the serving of the sentence during all stages. It may be during investigation, it may be during trial, it may be during appeal, or it may be during revision. We don't know what is pending. So before trial or during trial, we have to reckon, we have to compute the period by taking all this period, and then if it comes to 50%, he can be released on bail. It is a mandatory compliance. So here, Bhim Singh case, it is important. What is this Bhim Singh case? Supreme Court in Bhim Singh case told that, and direction has been given to all sessions and magistrate judges. They have to sit in jail. They have to sit in jail for at least once in 2 months. Once in 2 months, they have to sit in jail. And what they have to do? They have to conduct search and inspect and examine. If there is any accused beyond 50% of served beyond 50% or up to 50%, then he may be released on bail. What this section mandates is being done by bi-monthly. This is the direction given in Beam Singh case by Supreme Court. So this is one important aspect we have to learn. Next. $440. What is 440? What is section 440? Before that 436, 437, 438, and is there. 436 deals with what? 436 deals with the bailable cases. How to deal with bailable cases. 437 deals with the non-bailable cases. 438 deals with the anticipatory bail. 439 deals with the special powers of the High Court and the Sessions Court regarding bail. So, conditions imposing, conditions relax, and all other powers. Imposing of the bond amount and surety amount. 440 decides surety amount. So it should be with giving due regard, by giving due regard to the facts of the case and financial position of the accused. So by taking these considerations, court should impose surety. Court should impose surety. The circumstances of the case and satisfy bond is not excessive amount. This is the language of the section. Court should not impose excessive amount. Excessive amount as a what do you call? Bond amount. So that should be taken into consideration. Next. Even 436A also applicable to special acts. What is this meaning? 436A release by off sentence. Special acts are serious offences. Even for serious offences, 436A applicable. That is the concept of Supreme Court. Next, how to deal with economic offences. For economic offences, there is a landmark judgment that is called P. Chidambaram. We know that P. Chidambaram, ex-minister, Congress minister, he also involved in the money laundering case relating to Tamil Nadu state. Recently, he went to jail 2 years back or something. 2 years back, yes, 2-3 years back. So, in that case, P. Chidambaram case, in that case, some guidelines have been issued. What is that? The seriousness of the offense. The seriousness of the offense. That means the gravity of the offense. And the object of the special act. Object of the special act means, suppose it is Prevention of Money Laundering Act. Prevention of Money Laundering Act. Money laundering should be prevented. The money of the state should not be misappropriated. So, by keeping the mind, uh, by keeping this point in mind, the court should deal with the bail application. So, the object of the special act also. And attending circumstances. Attending circumstances means the circumstances involved in the offense, crime, involved in the crime other than major issues. So the attending circumstances, all these things have to be taken into consideration by the court while granting bail. And what is the maximum offense sentence? What is the maximum sentence awarded? This class is very useful for mains and as well as preliminary and as well as practice also. So you should keen in listening the class. These are the points for 2 marks questions. How to deal with the economic offenses regarding bail. What is 436A? These are very important on several aspects. So next, in NDPS cases, under trial prisoners, Supreme Court Legal Aid Committee versus Union of India case in 1994. In these cases, several directions have been issued. Suppose, what are those directions? If NDPS Act, the accused completed 5 years of sentence. 5 years of sentence, he can be released. But here some difference is there regarding fine amount. So, basing on the seriousness of the offense he involved in NDPS. NDPS also there are various types of offenses. I will come to that. Suppose punishment of imprisonment of 5 years or less and fine. So here you punishment 5 years or less plus fine. Then he can be released if he has in jail for a period which is not less than half the punishment. So suppose half the punishment, not less than half the punishment, he suffered the punishment. That means sentence. So then he can be released. This is one situation. The other condition is that he should pay 50% bail amount, fine amount. 50% of the said fine amount has to be surety. This is the condition. The next situation is that the offense is different. Punishment exceeding 5 years. Here punishment is 5 or less. Suppose above 5 years and fine. What is the fine amount here? It is, suppose punishment exceeding 5 years and fine. Such he shall be on bail as it is. But fine amount should not less than 50,000. This is bail surety. Why? Because because the offense is more, this punishment is more than first situation. In first situation, punishment is below 5 years, but in second situation, the punishment, the sentence is above 5 years. So, for safety purpose, surety has been increased up to 50,000. And the third situation is same, exceeding 5 years, but fine exceeding 5 years means 10 years. Third situation, it is, of course, it is 10 years. What is the difference between exceeding 5 years and 10 years? So 5 to 9 years. The second situation is 5 to 9 years, but in third situation it starts from 10 years. So if it is start from 10 years and fine, then surety amount is 1 lakh. Because more serious, more fine, more surety. That is the direction given by the Supreme Court. Of course, there are general conditions. I don't want to go into all those conditions. He should attend a police station. He should submit his passport. If he does not have passport, he should give statement or affidavit that I have no statement, I have no passport. So certain, what do you call, general conditions also imposed. So by seeing all these things, what we can understand is that court is intending to enlarge the accused, particularly under trial prisoners, by keeping their right to life, by keeping their precious rights of freedom. Earlier, this type of directions are not there. Now you have seen that transit. Yesterday you may hear the word transit anticipatory bail. Transit anticipatory bail. Even by the court, which is not having jurisdiction. Even the crime is registered in other state. Earlier, there is no such procedures, such relaxations. Suppose crime is registered in Maharashtra, accused in Andhra Pradesh, then he can approach an Andhra Pradesh court. Till I got bail from Maharashtra court, during this transitional period, bail may be granted. He can file that, of course, subject to some conditions. So, law is developing towards the personal liberty. That we have to take into consideration. Law is developing. That means respect to Article 21, respect to personal liberty, respect to personal freedom is going day by day. That we have to take into consideration. Earlier, this much of law has not been developed. But of course, these relaxations and these are not available for some of the people due to technicalities. Okay. These are some of the important aspects. Now come to other directions. Other directions given by Supreme Court in what do you call? Satyendra Kumar until Satyendra Kumar until versus CBI. This is important. Now the entire judiciary in India is following the guidelines given in this judgment by Supreme Court. This is the law of the land at present. All these discussion, all these points are discussed in that judgment. So what is the ultimate directions? Number one, government should consider to enact a bail law, bail act. In other countries like America, London, this bail act is there. Granting bail is a right in those countries subject to some conditions. It is a right. Here discretion. I am asking one question, let me know. You see section 436, 437, 438 and other bail sections. Bail to be taken. The language used in these sections is bail to be taken. Taken from whom? From accused. What does that mean? Normally, what we are understanding is that bail will grant by court. Is it correct? Can anybody say? Who grant bail? Who gives bail? Normally, bail has to be taken from the accused. Because what is the meaning of the bail? Bail means surety. Bail means security. So, bail has to come from the accused. Bail order will be the acceptance of bail and allowing that bail is done by court. But bail has to be given by the accused. So normal parlance, releasing the accused with certain conditions is called bail. So bail act should be done. That is the direction given to the government by Supreme Court. The other things is, if it is a regular bail, within 2 weeks it should be disposed. Suppose it is a anticipatory bail, it should be disposed within 6 weeks. And regarding section 170, no need of the forwarding accused to magistrate while filing charge sheet. So even the important aspect is that there is no need of filing bail application. No need of filing application for bail. Regarding section 88, section 204, section 209 and 170, etc. In these circumstances, if magistrate court or sessions court finds that he deserved for bail, even without waiting for bail application, the court then and there can grant bail by recording reasons. Speaking order has to be passed. Speaking order has to be passed. So, even without bail application, bail can be granted. To that extent, courts went nowadays. At the same time, section 167, clause 2. What is this section 167, clause 2? This is default bail. Of course, we will deal with that section, exclusively that section in further classes. But 167.2 is a human right aspect. Human right aspect. What is this 167 clause 2? Default bail. If the investigation agency fails to complete the investigation in a time given by the statute, it is the benefit, it is the right of the accused to get bail by default. Immediately after completion of 90 days, application can be filed by the accused in magistrate court and can get that bail under section 167 clause 2. The benefit is given to the accused because it is your failure of the state to conduct an investigation. So here, innocence of the presumption of innocence prevails. Presumption of innocence till proving the guilty prevails, and default bail can be granted to the accused under 167 clause 2. So these are the some important aspects from the stage of investigation to completion of the trial, appeal, and revision. These are the guidelines to be followed by the judicial courts, I mean judges and sessions court, while considering the bail application. So I want to close at this point. Any doubts?